The moment a police officer sees your gun, you can be completely legal and still end up in handcuffs in under 30 seconds. Not because you did anything wrong, but because you said the wrong thing or didn't say anything at all. Most armed citizens lose their rights right here, and they never even realize it happened. In the next few minutes, I'm going to explain exactly what the 4 words are, why silence alone isn't enough, and how to say them without escalating the encounter, because this is one of those situations where being nice can feel safe in the moment, but becomes a disaster later when your own words are used to justify what happened to you. Let's start with the hard truth. The moment an officer visually confirms a firearm, the encounter is no longer normal. That doesn't mean you're guilty. It doesn't mean you did something wrong. It means the legal lens changes. Courts give police wider room to operate under officer safety principles, and they do it for predictable reasons. A firearm raises the perceived risk level instantly, and that risk level drives police training, policy, and the way courts evaluate what happened afterward. When you're carrying, you might think the conversation is still casual. To the system, it's no longer casual. It's an event, it's documented, it's reviewed, it may be logged, and whether you realize it or not, the next 60 seconds often determine whether your encounter ends as a polite "have a good day" or becomes a detention, a search, a seizure of property, a revocation fight, or a criminal charge you never saw coming. Now, here is the big misconception that destroys people. They think compliance and consent are the same thing. They are not. Compliance means obeying lawful commands. Step back, keep your hands visible, don't reach for your waistband, stay in the vehicle, exit the vehicle, whatever the lawful command is in that moment. Consent is different. Consent is when you give permission for police to do something they might not otherwise be allowed to do without a warrant, probable cause, or a specific legal basis. And what most lawful carriers do, because they're trying to be cooperative and non-threatening, is they accidentally consent to things without even knowing they did it. They answer questions they didn't have to answer. They volunteer information that becomes suspicious once written down. They agree to just real quick actions that later become the legal justification for a deeper search or a longer detention. And once consent is in the record, your ability to challenge what happened collapses. So, what are the 4 words? I do not consent. That's it. 4 words that do not sound dramatic, do not require an argument, and do not need a speech. They're not magic. They don't prevent an officer from taking lawful safety steps, but they do something incredibly important. They remove the claim that what happened next was voluntary. They preserve your ability to say later, through counsel, that you did not waive your rights. And that matters because courts treat consent like a golden key. If the officer can say you consented, most of the constitutional fight ends right there. Judges often won't even reach the deeper question of whether the officer had enough justification, because consent short-circuits that analysis. Here's how these encounters actually unfold in real life. You're at a traffic stop, you're at a gas station, you're leaving a grocery store, you're on your own property, you're open carrying, or your concealed carry becomes visible when you reach for your wallet, or your shirt rides up, or you bend over, or the wind catches your cover garment. The officer sees the firearm and their tone changes. Even if they stay polite, the encounter becomes procedural. They ask, "Do you have a weapon?" or "Are you armed?" Or they skip the question entirely and say, "Keep your hands where I can see them." You, being a normal human, want to calm the situation down, so you start talking. "Yes, officer, I have a permit. It's legal. I carry every day. I'm a law-abiding person." You think you're helping. In many cases, you're building the foundation for the next step against you. Then come the questions that sound harmless but aren't. Where is it? Is it loaded? Do you have anything else on you? Mind if I secure it for now? That last one is the trap. Mind if I sounds like a request, and most people respond like it's polite conversation. They say sure, they nod, they hand it over, they point to it. They lift their shirt, they open a glove box, they unlock a console, they step out and let the officer just check something. And later, if that gun ends up being handled improperly, or it gets run through a serial check, or you're delayed while they verify, or you're searched further, you find out the hard way that the legal record says you agreed. It says you consented, and once that happens, it becomes incredibly hard to argue you were unlawfully searched or unlawfully seized because the court will ask one question: did you give permission? If the answer is yes, you're done. This is why I do not consent matters. It's not about being difficult, it's about clarity. Courts love clarity. Officers understand clarity, and you need clarity on the record. You can say it calmly, you can say it respectfully, you can say it once. Officer, I do not consent. That's it. And then you stop volunteering. You still comply with lawful orders. If you're told to step back, you step back. If you're told to keep your hands visible, you do it. If you're told not to reach, you don't reach. You do not argue on the street. You do not physically resist. You don't escalate. You simply do not waive your rights. Now let's talk about the second piece that people always get wrong, and it's the don't talk issue. You've heard don't talk to police, and that's generally good advice, but it's incomplete because people think silence is automatic protection. It isn't always. Silence before you invoke your rights can be ambiguous. Silence after you invoke your rights is powerful. That's why the next phrase you need in your toolbox is, I choose to remain silent. Again, you say it once politely, and then you actually shut up. Not, I'm not trying to be rude, but not, I just want you to know. Not, I'm a good guy. Not, let me explain. None of that. Because once the questions start, every answer becomes a thread, and officers, like anyone doing an investigation, pull threads. If you think, well, I'm not doing anything wrong, so my answers can't hurt me, you are ignoring the most important rule of legal reality. Innocence does not prevent misunderstanding, misinterpretation, or selective memory, and it doesn't prevent the system from using your statements against you. People talk themselves into probable cause. They talk themselves into inconsistent timelines. They talk themselves into appearing nervous. They talk themselves into admissions that aren't even admissions, but sound like one when written down. I'm carrying because it's a rough neighborhood. Congratulations. You just gave a narrative that can be spun as fear, suspicion, or intent. I forgot it was in the car. Now you sound careless. It's not loaded. Now, if it turns out it was loaded, you look like a liar. I only had one drink. You see how fast this goes sideways? And armed encounters are especially dangerous because the presence of a gun raises the stakes for everyone. That means police are more likely to take control measures. That also means your body language will be interpreted more harshly. If you reach too quickly, it's furtive. If you fidget, it's nervous. If you talk too much, it's over-explaining. If you don't talk, it's uncooperative. You cannot win this vibe contest. You win by being calm, being compliant with lawful commands, and preserving your rights so you can fight later if the officer crosses a line. Now let's address the big fear. If I say I don't consent, won't they cuff me? Sometimes yes. But here's the truth that people don't want to hear. If the officer is going to detain you improperly, your consent won't stop it. Your politeness won't stop it. Your permit won't stop it. But your consent will stop you from challenging it later. Handcuffs are temporary. Consent is permanent. I'd rather you be briefly detained with your rights preserved than walk away smiling while you just gave away the only legal tools you would have needed if it went wrong. Because when it goes wrong fast. And when it's over, it's not the officer you have to persuade, it's the court. Let's talk about what courts actually look at. They look at whether the encounter was consensual or coercive. They look at whether a reasonable person would feel free to leave. They look at whether you agreed to a search. They look at whether you gave permission to handle or seize the firearm. They look at whether you made statements voluntarily. And if your behavior suggests consent, nodding, handing things over, opening compartments, stepping aside without being told, answering questions, the court may treat that as voluntary cooperation. This is why you have to be explicit. I do not consent. It draws a bright line. If the officer proceeds, they must justify it under law, not under your permission. Now, a very important nuance. In some circumstances, an officer may lawfully secure a weapon temporarily, even without your consent, depending on the jurisdiction and facts. The point of not consenting isn't to prevent every action. It's to prevent the action from being treated as voluntary. because voluntary action is what kills your later challenge. If the officer truly has a lawful basis, they can articulate it. If they don't, you want that lack of basis exposed later, and you can't expose it if you handed them consent. Another retention killer mistake is people turning this into a street debate. Do not debate on the street. Do not argue constitutional doctrine at the curb. Do not say you can't do that. Do not say, I know my rights. Do not lecture. That tone shifts the officer from safety check into control battle. You don't need that. You're not trying to win emotionally. You're trying to preserve legally. Your entire goal is to be the calm, boring person on body cam who clearly stated non-consent, clearly invoked silence, complied with lawful commands, and gave the government nothing extra to use against you. So, what should you actually say in normal human language without sounding like a robot or a YouTube lawyer? Here's a clean version that works. Officer, I will comply with lawful orders, but I do not consent to any searches. Then if they ask questions, you say, I choose to remain silent. If they keep pressing, you repeat one time, I'm invoking my right to remain silent. And then you stop. That's it. No speeches. No sarcasm, no attitude, calm voice, steady hands, slow movements, compliance with commands, and zero volunteering. And please understand something. Your permit does not waive your rights. Your gun being legal does not waive your rights. Being a good guy does not waive your rights. The Constitution is not a reward you earn by behaving. It's a boundary the government is supposed to respect. But in the real world, that boundary is only enforceable if you don't voluntarily step over it yourself. Now, what about identification? That's where state law matters. Some states have duties to inform in certain contexts, some don't. And stop and identify laws vary. I'm not giving jurisdiction-specific advice here because I'm not your lawyer and your state matters. But the principle remains the same. If you have a legal obligation, you comply with that obligation. You don't volunteer beyond it. You don't expand the encounter beyond it. And you do not consent to searches just because the officer asked politely. A polite request can still be a constitutional trap. Finally, let's talk about what happens after, because most people think the encounter ends when they drive away. If you were detained, disarmed, searched, or questioned, the real fight starts after. Reports are written, statements are summarized. Subject admitted becomes a line in a report even if you didn't mean it that way. Subject consented becomes the key that unlocks the search, and you don't get to rewrite that later. That's why your best protection is what you do in the moment. Clear non-consent, clear invocation of silence, calm compliance, and no extra talk. So here's the takeaway, and I want you to remember it like a checklist. When police see your gun, the encounter changes. Don't panic, don't reach, don't over-explain. Keep your hands visible, move slowly, comply with lawful commands, and use your words like a lawyer would want them used later. I do not consent, then I choose to remain silent. That's how you avoid volunteering your rights away. That's how you reduce the chance you get boxed into an expanded search, and that's how you keep your options intact if the encounter goes sideways. If you want more of these, tell me in the comments what state you're in and whether you open carry or conceal carry, because the details matter, and I can walk through the exact do's and don'ts that apply where you live. And if you've ever had an encounter where the officer saw your firearm and things escalated fast, drop what happened. Keep it general, no names, no case numbers, because those stories are how we all learn what the law looks like in real life, not just in theory.